Welcome once again to Lehto's Law. Here's Steve Lehto.
I did a video very recently about an attorney in Texas who had gotten himself into a bit of trouble, apparently, because a court had ordered him to show cause why he should not be in a lot of trouble with the court, because he filed an affidavit that appeared to have been signed by somebody who had died prior to its signing. And so the hearing date's coming up, and I did the video, and I said, we'll see what happens. Show cause hearing, get to explain yourself to the court. And David sent me notes and said, Steve, check this out. Interesting twist to that story. Houston lawyer ordered to explain allegedly falsified affidavit. The attorney says the expert he used is not dead, but is in fact the son of the man who died, and they happen to have the same last name. So this is the kind of thing where you go, actually, yeah, that makes sense. Now, mistakes were still made, but we'll talk about that. So from Cron.com, Timothy Malcolm wrote this. A notable Houston insurance lawyer has been ordered by a federal judge to explain why he apparently submitted a sworn affidavit signed by a man whom the judge said had been dead for nearly 11 months. U.S. District Judge in Southern District of Houston ordered the insurance lawyer to explain the affidavit submitted earlier last year as part of a case between his clients and Allstate Insurance. In a May 2024 court document, Allstate alleges the attorney submitted a sworn affidavit from an expert whose name is Richard Gadrow in a case over alleged water damage to property. The affidavit was signed on April 25th, 2024, but Allstate argues that Richard Gadrow, who signed the document, died in June of 2023. Based on those facts, it seems that plaintiff's counsel has knowingly falsified, or at least filed a falsified sworn affidavit for the purposes of deceiving the court. And that's the judge writing, closing it with threats of possible disbarment and a review of potential criminal charges, because if that does play out that way, then, it would be bad. However, an attorney representing the law firm of the lawyer told Cron, C-H-R-O-N, Cron.com, that the affidavit was signed not by the dead Richard Gadrow, but his son, who is very much alive, also named Richard Gadrow. Richard Gadrow, the father, passed away in June of 23. This is the attorney for the attorney. The April 2024 affidavit was executed by Richard Brandon Gadrow, who is the son, who worked with his father and continued to operate the family's business after the father's death. The case dates back to October of 2022, and they've been going back and forth about all kinds of stuff. And so at one point in time, Allstate says that the lawsuit itself is frivolous. And of course, the plaintiff's attorneys say that that's not the case. And in fact, they got $56,000 in damages that they think are in play here, along with some other stuff. So the estimate was signed by Richard Gadrow, and they're saying, yeah. And the signature was done by the guy who's alive, who is the son. So in May, Allstate raised its suspicions over the affidavit to the court, and the judge, in his order, wrote that the attorney knew that the man referenced in the allegations had been dead since at least December 2023. However, the judge wrote that the lawyer had previously been sanctioned for relying on an opinion from Gadrow, who spent the end of his life with brain cancer. But the attorney stands by his claim that the Gadrow who signed the affidavit is in fact alive. And it's Richard Brandon Gadrow, not the Richard Gadrow referenced by the other side. So the attorney now says that Allstate should have known this because they've worked with the son who has the same name. What's most concerning is that Allstate Insurance Company is well aware of this fact, having worked directly with Richard Brandon Gadrow, the son, on dozens of claims since June of 23, yet chose to make misleading allegations to the court. Now, this again is the attorney's attorney writing. This appears to be part of a coordinated effort to defame the attorney through misrepresentation of easily verifiable facts. We look forward to presenting these and other facts to the court. We are currently investigating filing one or more lawsuits for defamation. But here's the primary issue. that I have with this entire case is that there's an attorney. And by the way, when I said his attorney's actually from his firm. It's not like he's gone out and hired an attorney outside. He's got just other attorneys working with him, apparently. And so this guy is an attorney handling a case. He submits an affidavit to the court, signed by somebody. The other side looks at it and goes, hey, that guy who signed it died a year ago. He died before the signature was apparently applied to this document. Therefore, there's a problem there. And they filed a motion with the court, and the court looked at it and said, oh, you're right, this is very serious stuff. And now the attorney comes forward and says, no, it's the son of the guy, has the same name, which is fairly common, but there's a perfectly innocent explanation. So you might ask yourself, well, how did we get here? In other words, wouldn't this have been really easy to straighten out? And you'd think so. You'd think so. And I can tell you that in many courts, before you file something with the court, asking the court to make a ruling on something or to throw something out or to dismiss something or exclude something, or you ask the court for a ruling on something where the court's going to do something, you're supposed to call the other side and ask for their concurrence. Because I've had a situation before where my opponent called me up and said, hey, Steve, we think that of your 8-count complaint, one of the counts actually doesn't work. And here's why. And they explain it to me. And I go, okay, I'll stipulate to dismiss it. Now, I've also had an attorney file a motion saying that they want to have one of my counts dismissed because they don't think it fits anymore. And I try calling the attorney's office to let them know I'll stipulate to it. And they never take my call. So I go into court and stand up and they make their argument. And I stand up and say, Your Honor, I concur. Judge goes, why didn't you stipulate to this? And I say, I tried. I called them. I sent messages, nothing. And I've actually seen a judge, not on one of my cases, but on another case, absolutely blow his stack. I actually saw one party get up in front. I vividly remember this. One party gets up, says, Your Honor, here's what we're asking for. And they go into this whole explanation, 10-minute long explanation. They sit down. Other side gets up and goes, Your Honor, we'll stipulate to that. Judge goes, and why are we here? And this attorney says, they never called. When I got their motion, I called them, faxed them, I believe, back then, and said, I'll stipulate to this. I don't care. And no response. So I got to come today, make sure that, nothing bad and crazy happens. And we'll stipulate to it. And the judge tells the other side, stand up and just starts screaming at them. Because in Michigan state courts, there's a thing called a precipice. And the precipice in those days was I'm doing this to indicate it's a small piece of paper. It's not a full-size piece of paper, precipice. And the precipice actually says on it, parties, and then it says, what court you're in, case number, all that stuff. And then it goes, relief sought. And then it says, I certify that I have contacted the other party in an attempt to get this relief, in essence, without the court's intervention. And that relief has been denied. Or, I saw later language, they changed it where they said, or the relief was simply denied because of, and there can be reasons why you just assume the relief will be denied. Like, we're asking for the entire case to be thrown out and for there to be sanctions. No one's going to go, yeah, I'll agree to that. I like sanctions. No. And so the question I have here, and I don't know the answers to this question. I don't know, okay? Let's go back to facts. Man files affidavit with court, and it appears to have been signed by a dead man. Other side sees the affidavit and goes, hey, signed by a dead man. Did they call plaintiff's counsel and say, hey, can you explain this? This affidavit's got a date on it that appears to be after this man died. And the man on the other side of the phone call would say, oh, you're thinking of senior. We're working with junior. Now, apparently the men don't have names that have the suffix senior and junior, but that right there would explain it. Oh, okay. Now, I will also tell you that I personally think that if I was having someone sign an affidavit and they had the same name as somebody else I worked with who had died, I think I'd probably have them put on the signature block Junior or something to indicate that, or I would at least make sure somewhere, because many affidavits have not just the opinion of the person who's signing, but they'll often have their credentials. So, I'm a certified licensed this. I've been doing this for 25 years. I've handled hundreds of these cases. And in these hundreds of cases, I've come to recognize this, 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 and this. Then, in this case, I did this. And that right there could also be played with to make it clear that we're dealing with a different person. So presumably the father would have had a lifetime of experience compared to the younger person with much, much less experience. And so the affidavit actually said, I've been working for this company for so many years, founded by my father so many years ago, et cetera, et cetera. And then it would become very clear what's going on there. But if the affidavit wasn't clear, it would still be on, I believe, the defendants to make that phone call and say, hey, just so you know, we've spotted an anomaly with your affidavit. And are you saying this was signed by the man after he died? And the attorney then would have said, presumably, no, we're saying it was signed by his son with the same name. Oh, makes complete sense. And a lot of people were commenting in the comment section underneath that last video about how could the notary have done such a thing? Well, now we understand, and there's a very good reason how this could have happened innocently. The notary looked at the ID of Richard Gadro, the son, and said, yep, Richard Gadro, ID, there you go, boom, 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 notarize. Makes complete sense. So now I'll admit, I don't have firsthand knowledge of any of this. I'm simply going off what's in the news. So we'll have to wait and see what happens, because there was a show cause hearing set coming up. And the show cause hearing was where the court said, you need to, referring to this attorney, come in and show cause why you shouldn't be punished and sent in and reported for criminal activity and so on and so forth. And so presumably the attorney can walk into court with evidence that there's a son who does the same thing his father did, and he signed this affidavit. In fact, you bring in the son. The entire hearing takes 60 seconds. But if I was the judge, I'd look at the defense attorneys and say, okay, this is very easy to prove. Did you ever call him and ask him? But then again, I also have to point out that he never apparently called and told them. Or if he did, why are we here, as they say? So again, like I said, I've seen a judge absolutely blow his stack. I actually saw a judge, same judge, different case, actually look at one attorney and go, you guys are here and you didn't talk about this case? And the one attorney goes, no, we haven't talked. The judge goes, have you two ever talked before? And the attorney goes, no, we haven't. And he goes, jokingly, John Smith, Mary Johnson, shake hands. And he made them physically shake hands. And he goes, okay, now that you've met, go out in the hallway and talk for a little while. Get to know each other. Then come back in here with your motion. Because for some odd reason, there are people out there who are so geared up for battle that they don't realize that sometimes there's simple solutions for things. So, David, thanks for sending that. Timothy Malcolm wrote that. The Houston lawyer, ordered to explain the allegedly falsified affidavit, says he's got a really, really good excuse. It wasn't falsified, and it's an unusual set of circumstances, he says, but it makes complete sense. Who'd have thunk it? Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Life isn't a matter of milestones, but of moments.